Welcome to Impact Makers Radio, featuring industry thought leaders sharing problem-solving insights to help grow your business and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi, and welcome to another Let's Talk Divorce conversation. And on this segment of the show, ladies and gentlemen, I have family law attorney Lauren Riesenfeld, and she's also the associate attorney at the Meyers Law Group, PC. Now, Lauren is calling in all the way from Huntington, New York, and definitely in our eyes, she's considered to be an authority in the area of family law. Now, Lauren's going to be talking to you today about how to avoid a costly divorce. So, if you are a divorcing couple, you just might want to take a break, maybe even log out of Facebook or Twitter or anything else you happen to be doing right now. Dust off a notepad and pen and listen in to what Lauren has to share for the next 15 to 20 minutes or so. So with that said, let's not keep her waiting any longer. Welcome to the show, Lauren.
Thank you, Stu. I'm glad to be here.
You are so welcome. So, Lauren, let's make the best use of our time today. Can you briefly, of course, in your own words, describe the people who you serve, the people who you help, and the various types of situations that they find themselves in when they come to you for your help?
Certainly. So, I find that the clients that come to me are generally three different categories of people. They're either persons who are seeking a divorce or have suspicions that their spouse is seeking a divorce. They are people who have post-divorce issues, meaning after the judgment of divorce was already issued, there's an agreement in place or there's a court order in place that specifies specific terms that they need to comply with, and one of the parties is not complying with it, so they need to go back to court to address those issues. And the third type of client that I receive are unmarried couples who share a child and want to either enter into a child support arrangement or a custody arrangement that they can't agree upon themselves without court intervention.
So, Lauren, keeping in mind that anything you share with us today is not legal advice or even legal assistance, can you briefly share the most common misconception that you come across while you're out there working with divorcing couples? Now, I know there's going to be a whole bunch of misconceptions that you've come across, but if you could just share the main one, that would be great. Thank you.
Sure, Stu. What I find to be the most surrounding misconception regarding divorce is the fees that are associated with it. What most people don't realize prior to entering into their divorce is just how timely these actions are and how long these cases can drag on for. I've seen cases that last several months, and there are cases that can last several years. And on top of that misconception is the fact that most people believe that it's the attorneys who are dragging this process out, and that's why their fees are so high. But that's an incredible misconception amongst most people. The truth of the matter is that the clients are the ones who are in the driver's seat here. The clients are the ones who have complete control over the divorce process, and based on how amicable the parties are, will determine the duration of how long the divorce will actually take. So let me just explain to you a little bit more about how the fees work.
Sure.
When a client retains an attorney, the attorney will quote them a retainer payment. This retainer amount will be based on the specific facts and circumstances of each person's case. So one person's case will not necessarily be the same amount of costs for their divorce as it was for their friends or their family members' divorce. The attorney that will represent them can charge anywhere between $350 to $600 an hour for all of the work that is completed. In addition, each client is required to pay a retainer deposit up front to secure their fees and for the attorney to formally appear in that action. Once you pay that initial retainer fee, the time that your attorney spends on your case is then deducted from your initial retainer payment. However, what most people don't realize is just how quickly that initial retainer payment can be used. When you first start the divorce action, there are formal papers that need to be filed in order for the attorney to be stated as the attorney of record with the court system. Each letter, each phone call, each email, all of these things that the attorney does takes time. And so you are being billed that hourly fee regardless of whether it's 10 minutes, 15 minutes, 20 minutes, up to an hour and more. After that retainer fee is exhausted, the client will have to replenish the fee. So this can end up being quite costly if the client does not take into account, every phone call that they make, every email that they send, every text message that they send that they are being billed for. Now, although many matrimonial attorneys do get a poor reputation for charging high fees for a divorce action, the truth is that the client and their spouse are the ones who are in complete control of how expensive or inexpensive their divorce ends up being. Meaning, if you and your spouse can come to reasonable agreements and can agree on how to split your marital property, this will result in much less required court appearances and far less motion practice. The other issue when parties cannot agree on how to divide their marital assets is that this may result in the parties needing to hire experts, including accountants, business appraisers, home appraisers, and additional experts in order to obtain values on the property. Now, when you hire these experts, there's additional retainer fees as well as costs associated with those appraisers. So on top of paying your hourly fee to your attorney, you then have to pay these additional costs for these experts. The same is true for couples who are going through custody disputes. If parents can't agree on how to split the child's time between both parents and arrange for a fair agreement so that each parent has access to the children, this can result in a very costly custody battle. In addition, if custody is at issue, the court will likely appoint what's known as an attorney for the children, who has formerly been known as a law guardian. Now, the attorney for the children's job is to be the child's advocate in the courtroom. They will meet with the children, the attorney for the child will meet with the parents, and then they will make suggestions to the court based on their interviews on how custody should be determined in the case. Now, in addition to the payments that you're making for your own attorney, the attorney for the children will require a separate retainer fee that the parties will also be responsible for. Typically, the court will arrange the fee for the attorney for the child to be paid based on a pro rata share of the parties, meaning if the parties each make a 50-50 income, then they will split the fee 50-50. So based on the ratio of their incomes, that's how the fee will be determined. A lot of times, one spouse is unemployed or doesn't earn enough income to even contribute to the attorney for the children. In that case, the other spouse will be 100% responsible for making those fees. So in essence, if you're paying $400 an hour for your own attorney, and now on top of that, you're paying $400 for an attorney for the children, that's $800 an hour that you're spending. When cases arise when there's a serious concern regarding one or even both parents' fitness to be a custodial parent, the court will also likely appoint a forensic expert on the matter. A forensic expert can also be an extreme additional cost to the parties. Experts will also require retainer payments, just as the attorneys do, to perform their services. And then if that expert is thereafter needed to testify at a trial or a hearing, the expert will require an additional retainer payment just to be a witness during the hearing or the trial. A forensic expert alone can cost a party up to $25,000. So now you're taking into consideration not only your own attorney's hourly fee, the attorney's fee for the children, any experts that have been included, and now on top of that, you're likely going to have a hearing or a trial, and you're going to need those experts to testify. To have them testify, now you're going to spend another retainer agreement of $25,000. So if these parties can't agree, especially regarding custody, they're looking at a $100,000 custody dispute.
Okay, Lauren, thank you so much for that. There's plenty of great information there for our listeners to work with. Now, based on what you just shared with us and keeping client confidentiality in mind, could you just share an example of how you've helped someone who came to you with those challenges, with any of those misconceptions that you've just shared with us, and what kind of transformational results you were able to gain for them, please?
Sure. What I've seen with my clients is that, unfortunately, going through any type of divorce action, regardless of whether it's financial issues that are at hand or there's custody issues that are at hand, these people are letting their emotions get the best of them. And in doing so, their emotions are clouding their judgment for their ability to be reasonable. So when I represent my clients, I try to take a tough love approach with them, and I make this in an effort for them to overcome their clouded judgment during this difficult time. I believe in being completely honest with them, and I approach the situation and explaining to them that, for example, in a custody dispute, you and your spouse have equal parenting rights to your children. Regardless of how you feel about the other person, they are still entitled to 100% parenting rights to the child, just as you are. So what I try to explain to them is, although they might want to seek custody and they might want to fight for custody, the financial ramifications at the end of the day may not be worth the battle in terms of the outcome that they are looking for. In other words, if they're going to spend, let's say, approximately $75,000 on a custody battle, including forensic experts and the attorney for the children and perhaps medical experts, there is a very good possibility that you might not get the outcome that you wanted, meaning you could say, I would like to fight because I want sole custody. Now, how custody works in New York is there's two types of custody. There's residential custody and there's legal custody. Residential custody applies to where the child's going to live, whereas legal custody is applicable to legal decisions, generally revolving around medical, health, and educational issues for the children. When someone's fighting for custody, they're usually asking to be both the residential custodial parent as well as the legal custodial parent. However, courts will make their best effort to maintain joint custody between the parents, especially regarding the upbringing of their children. In addition, I like to explain to my clients that they're in the best position out of anybody else to decide how their children is going to be raised. In other words, if you would like to split parenting time with your spouse and you only have certain days of the week available, you're able to come to an agreement outside of the courtroom and say, these are my available work hours, these are the times that work for me, and if they work with the spouse, then they can come to a fair agreement. If they're going to go the other route, which is they're going to have court intervention, they're going to lead to an uphill custody battle, which is going to have a trial and then have the judge make the ultimate decision, the judge is not going to take into consideration the specifics that you would like them to. The judge is not going to take out a calendar and say to you, gee, what days of the week do you work? What times do you work? What works best for you? The judge is not going to do that. The judge is going to look at the calendar and say, half the week goes to mom and half the week goes to dad. And 9 times out of 10, both parties are ending up unhappy with the arrangement. So in my approach, I explain to them that once they receive a judgment of divorce, that's not the end-all, be-all here. They still have a child together. They are still going to be at college graduation. They are still going to be at their child's wedding. They are still parents at the end of the day. So they will need to work together, and in doing so, they will need to try and do that now without the use of their attorney. Once they can do that and they can grasp the concept that fighting for this is not going to ultimately end up with the goal that they have in mind, I have seen most of my clients steer away from leaning towards a costly battle and working with the other parent to come to a fair resolution that's in the best interest of their children.
Lauren, you've shared a lot of information in the short amount of time that we do have together today. And I'm sure any listener out there that has been listening to your insights so far would want to know a little bit more about Lauren. Who is Lauren Riesenfeld? What makes her tick? How does she feel when she wakes up in the morning? So let me just ask you that personal question, Lauren. It's a Monday morning. You've had a great weekend. The alarm clock goes off, 6 o'clock, 7 o'clock, whatever the time may be in your part of the world. And you have a full day ahead of helping clients who find themselves in that unfortunate position of being divorced. How does Lauren Riesenfeld feel about her day ahead?
Well, Stu, I am actually very excited in the morning. I enjoy being in this field of law in particular because it's an in-person experience. It's not the type of law where it's just paperwork or you're dealing with someone via email. You have real people, in-person contact, and you can see that you're making a significant impact in these people's lives. The other part of it is I never have the same day twice. I can go to work, I can have a to-do list, I can have a calendar, I can have a day where I receive a phone call and there was a domestic violence disturbance between my client and their spouse, and one of them is arrested now. And now I need to go down to the courthouse and I need to do an arraignment so that I can get my client released from jail. Or there's an emergency and I need to quickly draft a motion and I need to file a motion on an emergency basis and I need to run to the courthouse. So I never have a typical day. My day is never boring, and I love that. I thrive off of that. In addition, I appreciate the fact that my clients are going through the most difficult times of their lives. They are at their low, and they are looking for help in any way they can. They are very appreciative of the guidance that I can offer them. And sometimes they're just looking for someone to vent to at the end of the day.
With that said, I think it's a good segue into finding out even a little bit more about you, but this time more about your background and your education, and especially your experience as it all relates to the topic of family law. So if you could just briefly share a little bit about your backstory, I think that would be great for our listeners right now. Thank you.
Certainly, Stu. Well, I attended Northeastern University in Boston, Massachusetts for college, and I studied criminal justice there with the notion that I would be attending law school upon graduation of college. Once I graduated from Northeastern, I studied for my LSATs. I took a year off in between, and then I attended New York Law School where I focused my concentration on family law courses. Upon graduating from New York Law School, I immediately began working for a predominant matrimonial law firm in Garden City, New York, and that is where I first learned that being a matrimonial attorney was the right position for me. I found that I have the compassion for it as well as the strong will to fight for my clients in their best interests.
Okay then, Lauren, we're coming towards the end of the show. And I'd just like you for a moment just to close your eyes, if you will, and picture the kind of divorcing couples who come to you for your help. And they're wanting to dig a little deeper into the topic of avoiding a costly divorce process. Now, with that picture in mind then, Lauren, what final thoughts would you like to impart before we move on to finding out how we can connect with you?
The best advice that I can give anyone going through a divorce is that they are in complete and utter control of how costly the divorce can be, not only themselves, but their spouses as well. And what it boils down to is the reasonableness that each of them share while going through this process. Each party should pick and choose their battles, the battles that they involve their attorneys in. If there is small issues that they can communicate with one another and avoid paying $400 or $600 an hour each to schedule a play date or to schedule a doctor's appointment, that's in the party's best interest. It is without a doubt that non-combative spouses will always result in fewer costs and will, of course, minimize both parties' overall emotional stress. So my best advice to anyone going through a divorce would be to remain calm, to try and keep a reasonable outlook, and to try and negotiate in an amicable manner with their spouse and avoid the use of their attorney for minor details, only using them when absolutely necessary to minimize their costs.
So, Lauren, if there is somebody out there who feels they want to know more about avoiding costly divorce processes, how can they connect with you? Where would they find you, Lauren?
Well, Stu, if someone would like to contact me, I can be reached by email. My email is lr@bestnewyorkdivorce.com, or by telephone at my office with the Meyers Law Group PC. Our telephone number here is 631-784-7722. And I've also included a link to my firm's website on Impact Makers Radio's website.
Okay, so whether you're cruising down the highway, maybe you're even out shopping with your family and you've got your headset on, that's all we have time for today. So once more, that was Lauren Riesenfeld. Thank you so much for sharing so generously with us today, Lauren. You certainly have demonstrated, hands down, without a doubt, that you are a true educator and advocate for your client's success. So thank you.
Thank you, Stu.
You are so welcome, Lauren. And even more importantly, a huge thank you to you, the listener, for joining us on this very insightful and informative discussion with one of the top family law attorneys in Huntington, New York today. Don't forget, her name is Lauren Riesenfeld. Make sure you check her out, give her a call, drop her an email. You're certainly going to be in good hands. So again, I'm Stewart Andrew Alexander, and we'll be back shortly with some more leading divorce professionals in this, our series of Let's Talk Divorce Conversations. So until then, take care, have a great day, and we'll talk real soon.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.